and welcome to our channel where we simplify complex trade finance topics. Today we are diving into the stages and the life cycle of demand guarantee. This is part 1 of the detailed series of this critical instrument in international trade. Demand guarantees play an essential role in securing international trade transactions. Let's start by understanding the journey of demand guarantee from its creation to the point where a demand or document is presented. The foundation of any effective demand guarantee is good drafting. Clear, concise, and precise drafting minimizes disputes and ensures smooth execution. Here are some key tips for drafting demand guarantees. First one, avoid lengthy and overly detailed clauses. Second, incorporate rules like Urdg 758 or ISB 98, which cover most scenarios, reducing the need for additional provisions. Third, stay away from ambiguous terms, non-documentary conditions, and complex legal jargons. For example, instead of overcomplicating the document with irrelevant clauses, aim to draft it on 1 or 2 sides of A4 paper, especially if you are incorporating international rules. Poor drafting can lead to confusion, particularly between demand guarantees and suretyship guarantees. Now, what's the difference between demand guarantee and a suretyship guarantee? A demand guarantee is an independent obligation by the guarantor to pay on demand. Suretyship guarantee, on the other hand, is a secondary obligation tied to the actual liability of the applicant to the beneficiary. In practice, confusion often arises in situations like construction projects. Lawyers experienced in drafting construction contracts might also attempt to draft demand guarantees, but without understanding their independent nature, they may create complex, unworkable documents that blur the lines between demand and suretyship guarantee. So, who should draft the guarantee? Ideally, the applicant and guarantor should collaborate in the terms before filing the underlying contract. This ensures clarity and avoid last-minute issues. In case where multiple parties are involved, like a counter guarantee, all stakeholders should agree on the terms early on to avoid misalignments. A great starting point for drafting demand guarantees is the specific forms provided in the Urdg 758 booklet. These model forms streamline the process and incorporate all 35 articles of the Urdg by reference, ensuring compliance and avoiding common pitfalls. Now let's see the key tips for drafting demand guarantees. This guide will help you understand how to draft effective enforceable guarantees. So, let's break it down. First, Rule 49 remains as the terms recommended in ISTGP Article 8 are mandatory. In other words, even if you don't follow those specific guidelines, the guarantee remains valid. However, using those terms make your guarantee more robust and less prone to disputes. Now, Rule 50 is critical. Avoid referencing definitions from the underlying contract in your guarantee. Why? Because this can create an unnecessary link between the two, weakening the independence of the guarantee. Instead, define any terms directly in the guarantee, even if they are identical. Rule 51 highlights the importance of clarity in guarantee. Most guarantees specify a maximum amount. Remember, if a guarantee requires non-monetary obligations like completing the project, it's not considered a demand guarantee under Urdg 758, even if it claims to be on demand. Let's talk about referencing the underlying relationship as covered in Rule 52. It's best practice to mention the contract related to the guarantee. This helps avoid confusion, especially if multiple guarantees exist. However, Rule 53 warns against making payment or expiry conditional on the contract performance. That could reclassify the guarantee as a suretyship. Rule 54 advises against using generic terms like first-class bank or well-known international bank to describe issuers. Those terms are subjective and does not ensure reliability. Instead, specify the issuer's function like inspection company or a law firm for clarity. Expiry terms are another critical area. Rule 55 explains how to structure expiry conditions to avoid confusion. For example, instead of multiple overlapping clauses, use a hierarchy like this. This guarantee shall expire upon the earlier of A. Receiving specific documents, B. Notification that the bid was unsuccessful, or a fixed calendar date. Always write dates clearly like 4th May of 2024 to prevent misinterpretations. Rule 58 to 64 tackle governing law and jurisdiction. The Urdg rules are standard terms, not laws. Choose governing laws explicitly in the guarantee to avoid disputes. Similarly, jurisdiction should be clear and consistent throughout the life cycle of the guarantee, whether the court or arbitration system exists. Finally, exclusions. Rule 65 warns that removing part of the Urdg can affect how the remaining rules apply. If you exclude an article, state it explicitly in the guarantee to avoid misunderstandings. And that's a wrap of ISDGP rules for drafting demand guarantees. Remember, clarity and precision are key to avoid disputes. Let's see Article 34 and 35 of Urdg 758, which covering governing law and jurisdiction. These articles are essential for understanding the legal framework of demand guarantees and counter guarantees. So, let's get started. First step. This article establishes the governing law for guarantees and counter guarantees. Here is what it says. If the guarantee does not specify a governing law, it defers to the law of the location where guarantor's branch or office issued the guarantee. Similarly, for counter guarantees, the governing law is the location of the counter guarantor's branch or office unless otherwise stated. This ensures that parties have clarity on the legal system governing their agreement. However, specifying the governing law in the guarantee or counter guarantee can avoid uncertainty and potential disputes later on. Next, let's talk about Article 35, which addresses jurisdiction. While Article 34 determines the applicable law, Article 35 specifies which court has the authority to handle disputes. Here is what it establishes. For guarantees, unless stated otherwise, disputes between the guarantor and the beneficiary are resolved by the competent court in the country where the guarantor's branch or office is located. For counter guarantees, disputes between the counter guarantor and the guarantor follow the same rule. The court in the country where the counter guarantor's branch or office is located. This setup provides a clear and predictable framework for resolving conflicts. But just like governing law, parties can choose a specific jurisdiction in their agreement to suit their needs. Here is why Article 34 and 35 are crucial. They help establish certainty for all parties involved, and they reduce ambiguity and potential delays in resolving disputes. Also, they align the legal frameworks of demand guarantee with international best practices. To summarize, Article 34 is governing law defaults to the location of the issuing bank or office unless otherwise stated. In Article 35, jurisdiction follows the same principle but focuses on the court for dispute resolution. By understanding and applying these rules, business can better navigate the complexities of demand guarantees and counter guarantees. To sum up, clear and concise drafting is the key to successful demand guarantee practice. Many disputes and legal arguments arises out of poor drafting. There should be no need to draft a long demand guarantee with many clauses. Instead, if you are incorporating Urdg 758 in the demand guarantee or ISP 98 in the standby letter of credit, in most cases you should be able to draft the instrument one or two sides of an A4 paper. Only a few clauses will be needed because the answer to most potential questions are contained within these rules. ISBGP C49 to 66 provides further guidelines for drafting demand guarantees incorporating Urdg 758. A demand guarantee incorporating no rules may need to be a little longer because it will be necessary to include some additional provisions that would normally be covered in these rules. In all cases, good drafting of the demand guarantee or standby letter of credit involves the avoidance of the following. First one, terms that require an examination of the underlying relationship to determine if a claim should be paid. All that is required a brief reference to the underlying relationship to identify it, so that all parties know to which contract or other relationship the instrument relates. Non-documentary conditions. Do not include a condition that cannot be determined by the presentation of a specific document or by another source such as a guarantor's on record or a specified publicly available index. Third, ambiguous terms and excessive detail in the instrument. Fourth, complex legalistic clauses. These are often associated with suretyship guarantees. So, as we earlier discussed, one of the problems sometimes encountered with the demand guarantee is poor drafting that confuses a demand guarantee with a suretyship guarantee. You will remember that an independent guarantee, such as demand guarantee or standby letter of credit, is a primary undertaking by the bank in favor of the beneficiary and is payable on demand. The obligation of the guarantor or issuer does not depend on the actual liability of the applicant to the beneficiary under the underlying relationship. By contrast, a suretyship guarantee is an undertaking by the guarantor to pay the beneficiary as creditor sum due to the applicant as debtor. A suretyship guarantee is a secondary obligation in that it arises only if the applicant has a legal liability to pay the beneficiary. The guarantor's obligation is no greater than that of the applicant. As noted previously, it is important to pay attention to the fundamental differences between demand guarantee and suretyship guarantee, since many disputes arise out of the failure to make it clear that instrument is demand guarantee. For example, it is good practice to identify either in the heading or body of the instrument that it is an independent demand guarantee. Further, the text of the instrument should be consistent with the demand guarantee and not with suretyship guarantee. The incorporation of rules such as Urdg 758 reinforces this position. The potential confusion between demand guarantee and suretyship guarantee is less of the problem with standby letter of credit, since standby letter of credit will normally be treated as a primary independent undertaking unless it contains wording such as clearly convert it to a secondary undertaking. As we earlier discussed, who should draft the instrument? As you gain more experience in working with demand guarantees and standby letter of credit, you will find that you can draft an instrument quickly and effectively. However, there is sometimes tension over who should draft the instrument. If the applicant and the beneficiary are each represented by lawyers drafting the underlying contract, the lawyers may also try to draft the demand guarantee or standby letter of credit required by the terms of the contract. This is often a bad move, since the lawyers may have little experience of drafting an independent guarantee. On the other hand, if you are asked to issue such documents, you should not amend the terms agreed by the parties or impose your own draft without the consent of the applicant, since that might put the applicant in breach of the underlying contract. Ideally, the applicant should discuss the terms of the instrument with the guarantor ahead of concluding the underlying contract with the beneficiary. In a counter guarantee, it may be sensible for all four parties to agree the terms of the instrument before the underlying contract is concluded. As an example, in a construction project, the lawyer may be very experienced in drafting construction contracts, but may not be properly understand the nature and characteristics of the demand guarantee. A guarantee may be appended to the contract just before the contract is signed, without any proper consideration of the terms of the guarantee and whether it is intended to operate as a demand guarantee or suretyship guarantee. Further, even if there is a time for detailed drafting of the guarantee, each team of lawyers will try to include terms of the instrument that are more favorable to the respective clients. The result may be complex and unworkable documents. A good starting point of drafting demand guarantee subject to Urdg 755 is the specific forms an additional process at the back of the Urdg 758 booklet published by ICC. Using the Urdg and their model forms help to neutralize difficult drafts in guarantee drafting. More importantly, it results a concise text since all 35 Urdg articles are deemed to be a part of the guarantee by virtue of the reference of the Urdg. Now let's see how to draft a demand guarantee without rules. Today we are diving into a crucial topic for everyone working with demand guarantees. How to draft a demand guarantee when no specific rules like Urdg 758 or ISB 98 apply. Whether you are a professional or just starting out, this is essential knowledge. Let's get started. Before we dive in, let's quickly recap. A demand guarantee is a financial commitment issued by a guarantor, ensuring payment to the beneficiary upon demand if specific conditions aren't met by the applicant. But what happens if your guarantee is not subject to any rules like Urdg 758? You need to draft it with precision to ensure clarity and enforceability. Here is how. When drafting the demand guarantee without reference to any specific rules such as Urdg 758, you need to ensure it includes all the critical details. These are the name of the applicant, beneficiary, and guarantor. Clearly identify all parties involved to avoid confusion later. Second, reference numbers or other identifiers. This applies to both guarantee and the underlying relationship to provide clarity. Third, the amount or maximum amount of guarantee. Also, specify the currency to avoid disputes. Fourth, the expiry date or expiry event. Don't forget to clearly state when or how the guarantee will terminate. Fifth, terms for demanding payment. Include details and the conditions under which a claim can be made. Presentation format. Specify if demand must be in paper or electronic form. Seventh, language of documents. You should indicate the language to avoid misunderstandings. Eighth, liability for charges. You should clarify which party will bear any associated cost. These details are essential for operational clarity and to ensure the guarantee functions as intended. In addition to the basics, there are some extra clauses you should consider adding to enhance the guarantee. Irrevocability. Confirm the demand guarantee is irrevocable to ensure its reliability. Independence. Clearly state the guarantee is independent of other agreements. Effective dates. You should specify the time it comes into force, especially if it differs from issue date. Place and time of presentation. Define whereon when claims can be presented. Partial and multiple demands. Indicate if partial or repeated claims are allowed. Also, demand examination time. You should set a clear time frame for the guarantor to accept or reject demand. Notification provisions. You should include details on what information should be shared and with whom when specific event occurs. Assignment or transfer. You should specify if the guarantee can be assigned or transferred. Also, exception on liability. You should define any exclusions for the guarantor's liability. To ensure the demand guarantee is robust and effective, follow these practices. Clarity is key. Use precise and unambiguous languages to minimize the risk and disputes. Avoid omissions. While missing details will not invalidate a guarantee, it's best to include all relevant provisions for operational efficiency. Customize for requirements. Tailor the guarantee to meet a specific need of the parties involved, such as whether a statement of breach is required. Fourth, review thoroughly. Ensure all terms are aligned with the expectation of the beneficiary and the guarantor. To recap, if you are drafting a demand guarantee subject to no rules, you should include all details, which include name of the applicant, beneficiary and guarantor, a reference number to other information identifying the underlying relationship, a reference number of other information identifying the guarantee, the amount or maximum amount of the guarantee and the currency which it is payable, the expiry date and or the expiry event of the guarantee, the terms for demanding payment, whether a demand or other document shall be presented in paper or electronic form, the language of any document specified in the guarantee, the party liable for payment of any charges, the irrevocable nature of the demand guarantee, its time of entry into force if different from the date of issue, its independence, the place and time of presentation of the demand or claims, whether partial and multiple demands are allowed, the time for the guarantor to examine a demand and reject or accept the demand, any information due to any party upon the occurrence of any event, any provision relating to the assignment or transfer, and any exception of liability for the guarantor. And there you have it, everything you need to know about drafting a demand guarantee when no rules apply. By including the right details and clauses, you can create a strong, enforceable guarantee that protects all parties involved. Now, how to draft a demand guarantee under Urdg 758. In this section, we will be walking you through the essentials of drafting a demand guarantee in line with Urdg 758. If you are ready to enhance your understanding and create precise guarantee, let's dive in. First, what should you care about Urdg 758? The Uniform Rules for Demand Guarantee provides an internationally recognized framework to draft and execute guarantees. They ensure clarity, fairness, and enforceability in global trade. Now, let's look at the essential elements outlined in Article 8 for drafting a demand guarantee. Key components of a demand guarantee. When drafting a demand guarantee, include these crucial details. First, name of the applicant, beneficiary, and guarantor. Second, a reference number of both underlying relationship and the guarantee itself. The amount of maximum amount payable and the currency. Fourth, the expiry date or an event that defines the guarantee's expiration. Fifth, terms of demanding a payment, including whether documents should be presented on paper or electronically. Sixth, the language of the documents. Seventh, the party responsible for paying any associated charges. These elements are fundamental for clarity and proper execution of the guarantee. Beyond the basics, consider including a clause to emphasize that the guarantee is independent and irrevocable. This reassures all parties of the guarantee autonomy and reliability. It's also helpful to specify each party's address to avoid confusion over identities later. While these aren't mandatory, they add clarity and efficiency. Addressing Article 15, supporting statements. According to Article 15, a demand must include a statement of breach by the beneficiary explaining how the applicant defaulted. However, this requirement can be excluded if expressly stated in the guarantee under Sub-Article 15C. This flexibility allows the guarantee to cater the specific needs of the parties involved. Article 20. Timely examination of the demands. Now, let's discuss the guarantor's responsibility. Article 20 gives the guarantor 5 business days to examine a demand after its presentation. If the demand complies with the guarantee's term, payment must be made promptly. Use tools like ISDJP C49 and ISB 98 to refine your drafting process. By adhering to these guidelines, you will create a guarantee that's effective, enforceable, and aligned with international standards. By adhering to these guidelines, you will create a guarantee that is effective, enforceable, and aligned with international standards. Thank you for joining me today. If you found this video helpful, don't forget to like, share, and subscribe for more insights into trade finance and guarantees. Until next time, stay informed and stay ahead.